The matter before the court is Kennebec, 23266, Wade Hamilton versus the Board of Licensure in Medicine. Counsel, we're being streamed live on the web, both by video and by audio. Because of that, I'd ask you to introduce yourselves by saying your names for the record and the party that you represent, but I'd ask you to do it at the podium so the camera picks you up.
I'm Adam Lee. I represent Wade Hamilton, who is the appellant in this matter.
Good morning, Assistant Attorney General Michael Miller on behalf of the Board of Licensure in Medicine.
Thank you. And if you are ready to proceed, Mr. Lee, we'd be happy to hear your arguments.
Thank you, Your Honor. May it please the court, I have an admission to make. This court has made decisions and rendered opinions with which I disagree. At times in discussion with clients, I have made my disagreement with your decisions known. I feel comfortable expressing this to you because I'm confident that neither the main board of overseers of the bar nor this court will sanction me, nor will the overseers determine that simply disagreeing with this court means I have a mental illness. I'm also confident that neither you nor they will order me to undergo a neuropsychological examination for this admission. That, unfortunately, however, is not the position of the Board of Licensure in Medicine. Here, the board has taken the position that, one, the Maine legislature passed legislation that permits the board to, at any time, without any showing or predicate, order any licensed physician or applicant for licensure to undergo a neuropsychological examination, and two, that expansive, limitless interpretation...
Counsel, I see that the green light is on. Why is this not an interlocutory appeal, and why shouldn't we dismiss it?
Well, we have a declaratory judgment action that we brought along with this in the event that this was determined to be an interlocutory appeal, because there is an independent action that occurred here, which was the ordering of the neuropsychological examination. It's also compounded by the fact that if he were to not submit to that neuropsychological...
So are you agreeing that, put aside the declaratory judgment issue,
Sure.
and I can get to that, but are you agreeing that this is an otherwise interlocutory?
I'm not. It's a final agency action independent of all other actions.
Why?
Because the court has ordered him to undergo a neuropsychological examination.
And the
has on
impact,
its-
if he does not, is that it's considered an admission. So that sounds like a discovery kind of thing that he can say, I'm not going to do it, and then it comes up to us at the end of the disciplinary process. Why do we look at it before we determine whether there was a disciplinary problem?
Well, a couple of reasons. One, the statute provides that it's not just a discovery matter, it's not just an unadmission. There is no trial that occurs, there is no hearing that occurs. He is found to be disciplined from that moment.
But that
by the
hasn't
failure to
happened.
take the- It has not.
It hasn't gone the distance. I mean, he might prevail. He might win in the end. There's an admission here which would make it tougher for him to prevail. But ordinarily, if we don't have the penultimate decision made, we typically don't deal with him in the meantime. I mean, he could proceed ahead. And actually, the adjudicatory process hasn't even started.
Well, the adjudicatory, so
The complaint has been initiated.
there's two arguments here. One is, will there be ultimately an administrative hearing that
Right.
happens with regard to any potential disciplinary action? But separate from that is a final agency action, which is the ordering of the medical examination, the neuropsychological
But here's where I'm
examination.
struggling. If you had a personal injury action in Superior Court, right? And there was a request pursuant to Rule 35 to order an independent medical examination, and the party said, no, I'm not going to do it, or maybe they say yes, whatever. It doesn't matter. Do you think that that's appealable?
No, but the
But
effect
why,
of...
if that's not appealable, why is this?
Because the effect of this, per Section 3286, is upon which a final order of disciplinary action may be entered without the taking of testimony or presentation.
And it
of
wasn't entered. There was no entry of that final order.
evidence. There hasn't been an entry.
So it's
because
interlocutory.
It's not interlocutory because there's a separate agency action that has occurred. which
So
is the
every time
ordering
the
of
agency
neuropsychological
makes a
examination.
decision, you can appeal it?
when it's a final agency action.
Well, in that sense, the sense that you're arguing, it seems like every decision is final. We're going to admit this evidence, we're not going to admit this evidence. We're going to have this procedure, we're not going to have this procedure.
It's discrete in this instance, and I think I'd point you to some of your case law, which I don't have here because I'm not prepared for the interlocutory appeal question. Nevertheless, you've ordered superior courts have ordered in the past, in the administrative context, immediate suspensions of licensure. This court has found that those are independent final agency actions. This is like that, because the effect of it, including on the board's website, is to say he has been disciplined. That is an action from which he is presently suffering the
Are
consequences.
you saying that the board's website currently says he has in fact been disciplined?
It says, and this is in our reply brief, we cited to the portion of the board's website that does this, it says that he has an adverse filing against him for incompetent practice, engaging in conduct evidencing lack of knowledge,
That's
principle, or
filing. It
skills.
doesn't say that they found it to be true or that he was disciplined for it.
It indicates an adverse finding because of the ordering of the neuropsychological examination.
So what's the stat, what
prior
did
to-
what
can
did
I-
they do to his license?
I think this is an important factor. These hearings are supposed to be confidential until the hearing takes place. That is public.
Is it always public?
No, not preliminarily unless there's a final action.
Well, I meant the fact that something's been filed against somebody, is that public on the website?
It is.
Well-
Oh, no, sorry. That a complaint has been filed?
Yeah.
No, they're confidential until there's a hearing.
If this was a final order, why is it called on its face an interim order?
Well, I think that's a question I think you will ask the state. I don't know why they labeled it that. There's no contention that they've made in this case that it is a final agency action.
Did it,
Is or
That's the
isn't?
predicate
I'm
of their
sorry.
motion to dismiss on the declaratory judgment action.
I don't think it had attached to it the usual 80C notice that you have X dates to appeal, did it?
I'm
Which
not
it
sure. I'd
does
have to look
when-
at the record, but I mean, I think that's
When,
neither here nor there, since the state has considered this to be a final agency action.
why do
in
you
all of
say
their
it's
pleadings.
considered it to be final agency action?
That's the argument that they made with respect to their motion to dismiss the declaratory judgment action.
Well, can you elaborate on that?
Sure. I have to take out the big old record here. They've argued that because we have ADB,
80C,
sorry, ADC, which is an appeal of a final agency action.
Right.
That we have no other claims that we can make, that basically those claims would be duplicative of the ADC action.
because you have an avenue through 80C in order to, after you get final agency action in the ADC, you can then appeal under ADC.
That's not the argument that they made at the Superior Court level.
Well, the argument against the GJ action is that it was duplicitous. It doesn't have anything to do with whether the ADC was final or not.
It's if we have available to us the ability to challenge the action here, which is the ordering of the neuropsychological examination through an ADC, that necessarily means that challenging the neuropsychological examination is in and of itself a final agency action.
No. It means that you can challenge that when the ADC is done in front of the agency.
He will have already taken the neuropsychological examination.
He can
which means-
refuse.
Pardon?
He can refuse to take
And
that.
then he will be immediately disciplined.
No, that's just an admission.
No, it's not just an admission. The statute provides,
But then you can appeal the discipline if that happens.
mean-
And including the fact that it ought not to be granted on the basis of a refusal to undertake an examination that he shouldn't have been ordered to take in the first place. Isn't that all preserved if you appeal that discipline?
we discussed this with the state. That's why the state stayed the action in and of itself.
Well,
the Board
can
of
the
Licensure
state,
did.
I guess that raises a broader, let's assume the state has said all along, yep, we agree, this is final agency action. Does that bind us, given that that is a jurisprudential rule of what we would review?
It wouldn't, but it would be forcing the state to basically engage in what we think is a constitutional violation by ordering him to undergo the neuropsychological examination.
Well, let's talk about the other justiciability issue, which was briefed, which is
mootness issue?
the mootness issue. So it's my understanding that when there is a disciplinary action pending against a doctor, they're still supposed to apply for relicensing. It just puts that on hold. But here, he chose not to seek relicensing, which took away their jurisdiction over him. So how is this not moot?
Because, well, two reasons. One, they haven't dismissed the complaint, so there's still a pending complaint against him, which is its own form of disciplinary action. Two, what we talked about with the website. There are obvious collateral consequences to having a website indicating that he has an adverse finding against him, especially one that is projected to all of the national licensure registries, meaning that irrespective of Maine, if you
Thought
were
it
to
didn't
apply
say there was an adverse finding, something, there was an adverse, that there was a filing, I thought you said.
finding adverse finding.
Should the board dismiss the pending complaint as moot then?
If they would like to dismiss, I would have a more difficult claim that the case is no longer, or sorry, that the case is ripe if they were to dismiss the claim.
Their position is this appeal is moot.
If this appeal is moot, then they should dismiss the complaint and remove that adverse finding from their website. They haven't done that. So there's obviously still existing collateral consequences which render the case not moot.
Well, what they're saying is that when he was licensed, there was a pending action against him. And why is that, why does that make it so it's, how does that affect the mootness?
The board would be violating its confidentiality rules if it's merely a pending action.
Well, it's not
because-
pending, well, it was pending when he was licensed,
And-
correct?
It was pending when he was licensed, and it's still pending. Nevertheless, the complaint is. The adverse finding, which is the order of the neuropsychological examination, has happened. And they are now listing that on their website as an adverse finding against him, by name, in violation of their confidentiality orders, if this is a pending claim.
Is the website in the record?
The URL is in the record. Well, not in the record, sorry, it's in the reply. The issue came about because of the mootness question, which came in the opposition brief, and so it exists in my reply brief link there.
Well, there's a certain logic to the point that if this appeal is moot, then perhaps the complaint is moot. But that doesn't address the interlocutory issue. If the board takes the position that complaint is not moot, despite the fact that Dr. Armstrong does not, Dr. Hamilton rather, does not have a license, then presumably the board would proceed. And the request for examination is a step in that process. I mean, as you know, under Rule 35 of the civil rules, a request for a mental health examination is a form of discovery.
Right, and I would distinguish this from simply a form of discovery because of the way that the statute's worded, which is if he refuses to take the neuropsychological examination, it's do not pass go, do not collect $200. There's an order that enters as a final order against him.
And that's the appealable order, the final order.
Which if they choose to do that, obviously we'd be back here very quickly, and I don't know as a matter of judicial efficiency, it would make sense for this court to delay that question. Probably would have done some more research if I
Except
thought
if
the
you're no,
interlocutory question was coming.
if you're no longer a licensed doctor, then they can't order you to take the exam anymore, which is why it's moot.
Except for the collateral consequences that he suffers with the impediment to his licensure because of the continuing existence of the complaint, as well as the adverse finding that's listed on the website.
But if he hasn't maintained this, I don't mean to be flip, but if he hasn't maintained the license, I guess I'm still missing a bit of the collateral consequence of having something out there that doesn't pertain to him any longer.
Because he couldn't find licensure elsewhere, and there's been expression by the Board of Licensure that he is an incompetent doctor, both of which reputational harm comes from the collateral consequence, as well as precluding him from seeking licensure elsewhere.
Thank
I
you,
have a
Coun-
minute left, so I will.
Thank you, counsel. We'll hear from you in rebuttal. Attorney Miller?
Again, good morning, Assistant Attorney General Michael Miller on behalf of the Board of Licensure and Medicine. May it please the court. I think I'm going to turn first to what is obviously a concern of the court with respect to the finality of the interim order directing Dr. Hamilton to undergo an evaluation. It's the position that this final interim order is reviewable by this court under Section 11,007. 11,001, subsection 1. And the specific language there is that the last sentence, preliminary, procedural, intermediate, or other non-final agency action shall be independently reviewable only if review of the final agency action would not provide an adequate remedy. There is an argument, and this, if this court disagrees, the board would be fine with this being considered an interlocutory order. But the board considered the fact that he would have to undergo the evaluation and then subsequently have some kind of additional action be taken in order for it to be reviewable by the court. And as the court has noted, this particular order directing evaluation is investigative in nature. And so in the event that the board let's say the evaluation comes back and it's fine, and they otherwise see no issue with respect to the care that Dr. Hamilton provided to this patient, then there may not be ultimately any agency action, any final agency action for the court to review, because they may ultimately dismiss the complaint, for example. So there is one case in the law court where you treated the issuance of subpoenas as final agency action. I don't have the site with me. I believe it was the National Organization for Women case. But because of that case, it was the position of the board that this is considered a final interim order under that particular sentence in subsection 11,001 of Title V. In other words, that there may not be a way for them to challenge an order directing evaluation that didn't ultimately lead to some other final agency action that was reviewable. With respect to this, first of all, this appeal is not from any disciplinary action taken by the Board of Licensure in Medicine, as the court has noted, but rather from the order directing that Dr. Hamilton undergo a neuropsychological evaluation. And the relevant statute in Title 32, Section 3286, only authorizes the board to compel an evaluation of a licensed individual. And because Dr. Hamilton is no longer licensed with the board, this appeal is moot. By allowing his license to expire, Dr. Hamilton mooted his own appeal. But that doesn't preclude the board from continuing with its ongoing complaint investigation. The board retains jurisdiction over Dr. Hamilton.
That indicates that the underlying controversy, meaning whether Dr. Hamilton is guilty of a violation of the standards, is not moot. I mean, it may mean the appeal is interlocutory, but if the board intends to proceed with the complaint, how can we say the controversy's moot?
Well, because the order itself is what's moot, not the complaint. So what is going on is Dr. Hamilton is conflating and confusing the alleged collateral consequences of the pending complaint with the alleged collateral consequences of the order directing evaluation. And first of all, coincidentally, there's no record support for those alleged collateral consequences, and they're actually incorrect. There is nothing preventing Dr. Hamilton from applying for license in Maine or any other jurisdiction. And in addition, the pending complaint does not necessarily prohibit the issuance of a main license either.
Can I back you up a little bit? So is what you're, if I understand correctly, I just want to make sure I do your argument, which is that you thought you have taken the position that you think this is reviewable under 110011 because waiting essentially would not provide or may not provide adequate relief, maybe. Okay.
Correct.
But that because that's the reason that this would otherwise not be interlocutory, given that the board can no longer compel him to undergo the exam anyway, that really does moot what might have otherwise been a permissible interlocutory appeal.
Correct. And if this court considers this appeal moot, because by virtue of the expiration of his license, that in turn would moot the Superior Court decision, and the order directing evaluation would also become moot. So to address the statements with respect to the board's website.
Would the collateral consequence of declining to participate remain?
Conceivably, it's possible that the board could amend the current complaint or issue a new complaint for his failure to comply with their request while he was licensed for that conduct. That is, but that would not be ripe at this point in time. And because circumstances could change between now and whenever that might occur, it may alleviate the need for him, for example, to undergo an evaluation.
Is there currently an adverse finding against, posted on a website?
So what there is it's considered an adverse action, and that arises from the requirements of the National Practitioner Data Bank. Because the board issued an interim order, a final interim order, that became public. The order itself is on the website. What he's quoting to is the sort of a drop-down list that's on the alms licensing site that sort of categorizes stuff. But it doesn't indicate that any final action has been taken other than an adverse action in issuing the order directing evaluation.
Has it characterized him in any way as being an incompetent practitioner?
Well, the allegation, it doesn't say that they found that. It indicates that that order is associated with their trying to determine whether or not there is issues with respect to his competence.
If Dr. Hamilton were to contest the underlying complaint and were to prevail, would the current collateral consequence disappear? Or would that remain on his record that he declined to participate in a mental health examination?
Well, what's on the website doesn't indicate that he's declined. The only thing that's there is that the board has ordered him to undergo an evaluation. So there is not an actual finding in that sense that he's incompetent or anything else. All it is the posting of the order itself.
If he prevails on the complaint, does the effect of the order disappear?
The order, that's assuming that there actually isn't an effect of the order with respect to Dr. Hamilton. There is no direct effect on him. As I've tried to explain, there's nothing that prevents him from getting licensing in other jurisdictions.
But if the other state looks and says that he was ordered to take a mental health exam, isn't that going to cause further questions? And couldn't that be viewed as adversely affecting him?
And that's why we're here in front of the court today, to sort of determine whether or not, this is his due process, essentially, with respect to that particular order. And if the court finds that it's moot, then that order goes away. If ultimately...
No, what do you mean that order goes away?
Well, if you...
Let's say we find it moot, then what happens?
Then the Superior Court's decision is also moot, as is the order directing evaluation. And that would be, that information, the fact that it is now moot because he's no longer licensed, would be reported to the National Practitioner Data Bank. But that's all this is in conjunction with.
But then you said that doesn't take care of the complaint.
That's
So even
correct.
though he's not licensed anymore, while the order to take the exam goes away because they don't have authority over it, what happens, how is that process, that what remains?
All right, so the complaint is still in a pending pending status. The order directing evaluation is merely a piece of the board's investigation with respect to that particular complaint. So that there's other things that are ongoing, which is why this is, in some ways interlocutory, but there's other things ongoing. And the board will ultimately have to make a final determination with respect to the disposition of the complaint. The order directing evaluation is meant as a tool for the board to be able to determine whether or not there's an underlying health or mental condition that has contributed to the conduct that they are reviewing.
So
with
even
respect
if
to Dr.
everything is
Hamilton.
unwound back to the complaint, it could still move to an adjudicative stage?
That is correct.
And then a finding would be made?
That is correct.
But in the meantime, if this is mooted and the Superior Court decision is mooted and the order itself is mooted, does the National Data Bank website get changed?
There will be a report to the National Practitioner Data Bank indicating that the order is moot.
So you're
because-
processing the complaint. We've said this appeal is moot. Is there a possibility that he'll be ordered to take this exam again? Or do you start from a clean slate?
So there is the potential that the board, first of all, you have to assume that he applies for a license and that he ultimately gets a license.
But if he remains unlicensed, that you're saying the board cannot again order him
That is correct.
to take it?
Then how does it process the complaint that is pending?
Well, because the allegations aren't limited to solely the issues associated with the order. The pending complaint has other issues associated
You
with it.
could go
with
forward on the
respect to
complaint, you just wouldn't
Correct.
have the examination as evidence in the case.
That is correct.
Okay.
But if you can go forward on the complaint, how can we say the underlying controversy is moot?
Because the court is not today considering the complaint. The court is only considering the order directing
This
evaluation.
appeal could be deemed interlocutory, but I'm struggling to see how it's moot because there is no longer a justiciable controversy.
Because the complaint is not just the order directing evaluation. The only thing before the court today is that order. The board hasn't taken any disciplinary action.
So in the
And that
pending-
complaint is not only defined by
In
the
the
order.
pending complaint, there will be no adverse consequences from him having refused to take the exam?
There is none in the current complaint, that is correct.
Unless sometime in the future he were to become relicensed, and then you could start it over again. in
Assuming that
sense.
pending complaint is still is pending at that time, then they might conceivably amend their complaint and add the fact that he didn't comply with their earlier request. But again, that's all sort of speculative and in the future and wouldn't be right for the court to determine today.
Well, it sounds as though what's speculative is whether the board will ever dismiss the complaint.
Well, the board is going to go through its normal process, Your Honor, and that is it conducts its complaint investigation. And unfortunately, we are in an interlocutory place, and as he's pointed out, typically, investigations of the board are confidential. So, I can answer the court's question more broadly with respect to what the status of that current complaint investigation is, if you would like, but it's not in the record.
Is it proceeding?
It
or-
is proceeding.
Okay, because it hasn't been
And
stayed by
there
the
are,
appeal.
there are other issues, yes.
Okay.
So just so I'm clear, or to summarize, basically what you're saying at this point is from the board's perspective, other than with respect to the order to undergo the neuropsych evaluation, this matter is still interlocutory. Other than that issue.
That is
That's the issue that's
correct.
been presented to the court.
That is
That is what
correct.
makes this reviewable in the board's estimation.
That's correct, and
to
only the order.
And only the order, and to the extent that he is not licensed at this point, and so there's no obligation to undergo the evaluation. If
Yes.
we find this to be moot, everything unwinds, your investigation goes on, but it's still at an interlocutory phase.
Exactly.
If the investigation phase is completed and it moves to an adjudicatory phase, is there discovery available? What typically happens at that level?
So there is no discovery available at that point. I mean, the investigation arguably can sort of continue right up to the hearing, but then the hearing will be held, evidence will be taken, and the board will make a determination based on the evidence presented to it.
Thank you.
There's no further questions.
There don't appear to be additional questions. Thank you. And Mr. Lee reserved a minute for rebuttal.
Sure. That the collateral consequences are mooted by Dr. Hamilton no longer being licensed is belied by the fact that you can jump on Google right now, go to the Board of Medicine and Licensure's website, and find that there is an adverse action against him that says incompetent practice engaging in conduct evidencing lack of knowledge, principle, or skills to carry out the practice
Well,
for
that's
which
the
licensed.
pending complaint against
It's
you.
an adverse action from the
They
interlocutor.
didn't make a finding of those things. They're saying the adverse action is the examination.
And as Attorney Miller said, all of those other actions would be confidential otherwise. The action here is the ordering of the neuropsychological
And
examination.
that stands regardless of what happens with the complaint.
Correct.
But if this appeal is mooted and the Superior Court decision is mooted and the order is mooted, won't that be corrected?
It appears not,
That's what I understood.
It appears not,
That's what I
because-
understood counsel to say.
because if this was mooted, it would no longer be on the board's website.
Well, it's not mooted yet.
Thank you, counsel. As is our usual practice, we will take the matter under advisement and issue a written decision in due course. Thank you, counsel, for your arguments in this matter, and we will be in recess on this case.